All right, let's dive into a case that really starts like something out of a true crime show. Stormy night, isolated farmhouse in rural New South Wales, but it ends up changing Australian law.
Yeah, it's quite something. You've got this chilling scene, October 1999. A neighbor visits, seems ordinary. Then, bam, allegations of assault, a rifle involved.
Terrifying stuff. And it wasn't just the crime itself, was it? This whole thing ballooned into a massive legal battle.
Absolutely. 2 full years. There was the initial trial, then a really hard-fought appeal, and the final decision, well, it had huge ripple effects. We're talking about Picker VR 2002.
So for this deep dive, we're using the court judgments, the legal analysis, basically getting right into the source material.
That's the plan. We want to walk you through exactly what happened, who was involved, the twists and turns in court, and crucially understand how this case reshaped the way things are done in Aussie courtrooms.
It's a powerful mix, isn't it? The very human drama and the real legal consequences.
It really is. Shows how critical those procedural details can be. Something as simple as how a lawyer asks a question.
Okay, before we get bogged down in the timeline, let's quickly paint a picture of the people involved. Who are the key players here?
Right, the cast. So first up, you have Eric Russell Picker, local guy, grazier, salesman. He knew the complainant's fiancée from work. He's the accused, obviously, and later the appellant fighting the conviction.
And the complainant.
That's Donna Lucas. She was engaged to a guy named Mark Umbach, living out on her father's rural property at the time. The alleged crime centers entirely around her experience that night.
Got it. Mark Umbach, the fiancé. He wasn't there.
No, that's key. He was working away down in Mildura. He features mainly through a pretty crucial phone call just before things escalated.
Then there's Barry Moore, a neighbor.
Yeah, mutual friend, neighbor. Seems like he just happened to mention to Picker that Mark was away. Didn't know what would follow, presumably. Kind of sets the stage unintentionally.
Okay. Noni is mentioned too.
Picker's de facto partner. She wasn't directly involved, but Picker wrote letters to her afterwards, apparently expressing guilt about being unfaithful. Those letters come up later.
And Mr. S.A. Fryer, another friend.
Picker's friend, yeah. He becomes a key witness because Picker went to see him the morning after the incident. Fryer saw the rifle, heard a version of events from Picker, and got those letters for Noni. His testimony was pretty important.
What about support for Donna? Who did she turn to?
First person she called was Mr. Umbach Sr., Mark's father. He drove out, picked her up, saw how distressed she was. His testimony about her state right after the event was powerful corroboration.
And the police.
Detective Senior Constable Gray was the lead investigator, collected evidence, like the rifle case found later. He also received quite a distressed call from Picker, who sounded suicidal, and eventually took Picker's surrender.
Who oversaw the first trial?
That was Judge Roderick Howie, DCJ, in the district court. His decisions, or maybe lack of intervention at key moments, became a big focus of the appeal.
Right. And when it got to the appeal stage, Picker had new lawyers.
Yes, a fresh team. Philip M. Strickland acted as his barrister, and D.J. Humphreys was the solicitor.
And opposing them for the Crown.
On appeal, the Crown Counsel was P.G. Ingram, with S.E. O'Connor as the Crown solicitor.
And the judges who heard that appeal, these are significant names in Australian law, right?
Definitely. The panel at the NSW Court of Criminal Appeal was Justice Margaret Beazley JA, Justice Virginia Bell J. Both later went on to the High Court, and Acting Justice R.O. Smart. Justice Smart wrote the lead judgment, the one that really made waves.
Okay, quite the lineup. So let's trace the events. How did this all actually start before anyone even thought about courts?
It begins early October 1999. Don is out on this farm. Fiancé Mark's away working. The neighbor, Barry Moore, mentions Mark's absence to Picker. So Picker knows Donna's likely alone.
That feels ominous already.
It does. So October 11th, Picker just turns up unannounced. Donna arrives home, finds him there on his motorbike. They chat. She later recalled him making this weird comment, bragging about some young girl hitting on him.
Strange, but she invited him in.
Yeah, seems like she was just trying to be neighborly, polite. Gave him tea. They talked Amway, general small talk. That visit ended okay. Nothing happened, but the connection was made. He'd been there.
Fast forward a week, October 18th. Stormy night. Donna's alone again.
Yep. Around 8:30 p.m., she's on the phone with Mark, the fiancé. Long call. Then headlights pull up. It's Picker. Back again, unannounced. In a white ute this time.
And this time it's different.
Very different. Well, she's still on the phone to Mark. He doesn't even knock. Just opens the unlocked door and walks right in.
Wow, just like that.
Just like that. Donna's obviously startled. She quickly tells Mark someone named Roger has arrived, clearly floundering for a name. Mark hears the nervousness in her voice, but he hangs up to sort out dinner, not realizing the danger.
So she's alone with him now. What happens inside?
Well, Picker gives some excuse like checking Barry's cattle, knew he'd get a cuppa. More small talk. He vents about his partner, Noni. Then he says he better go, but then turns and asks, "Can I have a cuddle?"
And she refused.
She did. But he didn't take no for an answer. He lunged, grabbed her, physically lifted her off the lounge chair.
He pushed him away.
Yeah, she managed to push him off.
Yeah.
And interestingly, he stopped for a moment, showed that flicker of guilt again, saying something like, "I shouldn't have done that. You'll tell your father." Worried about the consequences right away.
But it didn't end there.
Not even close. He says he needs to get a letter from outside, goes out, and comes back carrying a rifle.
Oh, my God.
Yeah. Donna said her blood ran cold. And then he says it. "Tonight's the night I'm going to do myself in, and before I do it, I'm going to make love to a beautiful woman, and you're it, sweetheart."
That's effectively holding her at gunpoint. Any idea of consent is just gone. Completely gone.
Absolutely. It's aggravated assault right there. Donna, clearly terrified but trying to de-escalate, actually agrees to a compliant hug, just hoping he might leave then.
But he didn't leave.
No. He used the hug as an opportunity, picked her up, kissed her forcibly, said, "Come on, we'll take this a bit further." Donna pleaded, "Don't wreck my life." But with the gun there, she testified she didn't fight violently. What could she do?
He carried her into the bedroom.
Yes, into the dark bedroom.
Yeah.
Lightning flashing outside, apparently. Despite her saying, "Eric, don't do this," he took off her clothes from the waist down, partly undressed himself, told her to pull her top up.
And then the assaults occurred.
According to her evidence, yes. First, he performed oral sex on her. That became count 1. Sexual intercourse without consent, the oral act.
And then...
Then he climbed on top, asked this bizarre, chilling question, "Inside you or on your stomach?" She said, "On my stomach." He then performed vaginal intercourse, ejaculating on her stomach as she'd asked. That became count 2. Sexual intercourse without consent, the vaginal act. And afterwards, again, that flash of guilt. "I shouldn't have done that. You'll tell your father."
What happened after the acts?
He got dressed, left the bedroom. Donna was left crying on the bed. She got dressed, went back to the lounge. Picker was there, apparently apologizing over and over.
But then he did something else. Calculated.
Extremely calculated. Before leaving, he ripped the telephone cord right out of the wall, took the phone handset and the rifle with him. Donna watched him walk away, phone in one hand, gun in the other, cut off her lifeline.
That act alone, ripping out the phone cord, speaks volumes.
It really does. Shows intent to prevent her reporting it, doesn't it? Utterly chilling.
So what did she do? How did she get help?
The second he was gone, she ran. Through the storm to a neighbor's place. It's early morning now, October 19th. And interestingly, she didn't call 000 first.
Who did she call?
She called Mr. Muback Sr., her fiancé, Mark's dad, over in Bega. Told him what happened. Eric Picker. Rape. Gun.
And his testimony about her state was important later.
Crucial. He described her as absolutely distraught, sobbing, shaking uncontrollably. He drove straight out to the farm, collected her back. She was traumatized, trembling, and took her straight into Bega. That immediate complaint, her obvious distress, strongly supported her story.
Then the authorities got involved.
Yes. From Bega, the police and ambulance were called. She was examined at Bega Hospital. Detective Gray interviewed her. Despite the trauma, he noted she gave a coherent account. The police took it very seriously, especially the firearm element.
Okay, so while Donna is getting help, what's Picker doing?
He's essentially on the run. Morning of the 19th, he turns up at his friend's place, Mr. S.A. Fryer, and he still has the rifle with him.
And he talks to Fryer.
He does, gives a partial self-serving version. Said he went to a woman's place for Amway. She came on strong. He went for it, but then she cried rape. Big difference from Donna's account, obviously. But critically, he admits sexual contact occurred.
And he gave Fryer those letters.
Yeah, letters for his partner, Noni, expressing guilt about being unfaithful. Then he took off again, still with a rifle. Fryer's testimony later was key. It placed Picker with the gun the next day and confirmed he admitted sex happened. The fight was always going to be about consent.
Then Picker calls the police himself.
Sort of. Later that afternoon, Detective Gray gets a call from Picker. Picker sounds suicidal, says he's sitting here with a gun between my legs but won't say where he is. Gray tries to talk him into surrendering. The call ends.
But he does surrender eventually.
Yes, the next day, October 20th, he goes to Bega Police Station, but not alone. He brings his solicitor, DJ Humphreys.
And the solicitor advises him.
Immediately, Mr. Humphreys tells Detective Gray straight up, Picker won't be giving a statement, won't answer questions. Picker himself politely invokes his right to silence on legal advice. Smart move, legally.
So the police charge him based on Donna's statement and the other evidence.
Exactly. 2 counts of sexual intercourse without consent, oral and vaginal, plus possessing a firearm with intent to commit an indictable offense, the sexual assault. Picker pleaded not guilty to everything, claimed consent, denied using the gun as a threat. The case then moved up towards a district court trial.
So the trial itself, late 2000, Judge Howie presiding, 3 days. Sounds like it boiled down to credibility.
Pretty much. It was Donna's word against Picker's. Limited forensics, it seems.
Yeah.
A classic oath against oath situation. Jury trial. We don't have the specific names of the trial barristers, but there was a Crown prosecutor and a defense barrister.
How did the prosecution lay out its case? What was the core argument?
Main weapon, Donna Lucas's testimony. Powerful, detailed account of the night. Then they bolstered it. Mr. Umbach Sr. and the neighbor testified about her immediate distress. Medical evidence from the hospital exam. And crucially, Mr. Fryer's evidence about Picker's comments the next morning admitting sex, having the gun. Plus, Detective Gray on finding the rifle case under Picker's bed and that suicidal phone call suggesting guilt. The narrative was, Donna is believable, her actions consistent with being a victim. Picker's actions and words point to guilt.
And the defense? Picker had to testify, didn't he?
Almost certainly, yeah. For a consent defense in this kind of case, the accused usually has to give their version directly. High risk, though. Puts them right in the crosshairs of the prosecutor.
And his version was completely different.
Totally. He claimed it was all consensual, flatly denied the gun was involved in the incident at the house, denied the oral sex ever happened.
So how did he explain the interaction?
He painted Donna as the initiator. Claimed she leaned on his shoulder, said things like, "The rain does it to me." Led him to the bedroom, even said, "I don't want to kiss, I just want sex." His explanation for feeling guilty afterwards. Just about cheating on Noni, the letters, the suicidal thoughts, all down to infidelity guilt, he claimed. The rifle in the truck. Just there from farm work, pure coincidence. The defense theory? She consented, then regretted it or got scared of her fiancé finding out and cried, rape. Pure credibility contest.
Okay, now we get to the crunch point, the cross-examination of Picker. This is where the legal controversy really ignites.
Absolutely. This is the heart of the appeal later on. The Crown prosecutor's cross-examination stepped over the line, according to the appeal court. 2 main tactics caused major problems.
Let's break them down. First, forcing Picker to call Donna a liar. Why is that not allowed? Surely the prosecutor wants to show she's telling the truth, and he isn't.
It seems logical on the surface, but it's fundamentally unfair in law. Asking, so she's lying about that, or that's something she just made up, puts the accused in an impossible bind.
How so?
Well, if he says, yes, she's lying, he sounds aggressive, maybe calculating. If he says no, or equivocates, he undermines his own defense. But the deeper legal reason is about the burden of proof. The Crown has to prove he's guilty. His job isn't to explain why the complainant might be saying what she's saying, whether it's a lie, a mistake, a delusion. He can only state his version of events. Forcing him to label her testimony distracts the jury from the real question. As the Crown proved its case beyond reasonable doubt, it shifts the focus unfairly onto the accused having to dissect the complainant's motives.
Okay, that makes sense. It's about fairness and where the burden lies. What was the second improper tactic?
This one involves a legal principle called Brown v. Dunn. Basically, it means if you're going to present evidence that contradicts what an opponent's witness said, you generally have to give that witness a chance to respond to your version while they're on the stand.
So in this case,
Picker's defense lawyer hadn't specifically asked Donna during her cross-examination about the things Picker later claimed she said, like, "The rain does it to me," or "I just want sex."
I see where this is going. The prosecutor used that omission against Picker.
Exactly. Pounced on it. During Picker's cross-examination, the prosecutor repeatedly asked him why these crucial details of his story weren't put to Donna. The heavy implication was clear. You just made this up after you heard her testify, didn't you? It's a recent invention.
Can you give an example of that exchange?
Yeah, the judgment quotes it. Prosecutor asks if "the rain does it to me" comment was put to Donna. Picker says, "No, I didn't." Prosecutor jumps in. "And that's because she never said such a thing to you at all." Picker was so frustrated he apparently shot back, "Ask my counsel why."
Wow. You can feel the tension. So that combination, making him call her a liar, A-N-D, suggesting his whole story was fabricated on the spot because his lawyer hadn't followed the Brown v. Dunn rule, was a double whammy.
The devastating one, in a case purely about credibility.
Yeah.
And compounding the issue, Picker's own defense lawyer didn't really object forcefully to these lines of questioning. Judge Howie only stepped in minimally late in the piece. The damage was largely done.
Did the defense lawyer try to fix it later in re-examination?
They tried, but the appeal court found it wasn't enough. They produced some handwritten notes, supposedly taken back in November 1999, which allegedly contained Picker's version, including those alleged flirtatious remarks. Counsel asked Picker if the notes confirmed his story. He said yes.
But the jury didn't see the notes.
That was the problem. The notes were marked for identification but never formally tendered as evidence, never read out. The solicitor who took the notes wasn't called to verify them. So the jury just heard Picker saying the notes backed him up, but they had no independent proof. It was seen as a weak, insufficient attempt to counter the recent invention suggestion.
Then came the closing speeches. The prosecutor didn't back down.
Not at all. The appeal judgment described the Crown's closing as florid and aggressive, called Picker's account the best fantasy novel ever written, absurd, a flight of fantasy, urged the jury not to give his evidence the slightest shred of credibility, and flat out accused him of total fabrication. Very inflammatory stuff, attacking the person rather than just the evidence, and repeating those points about details not put to Donna.
So even if the judge's summing up was neutral, the impact of that cross-examination and closing must have been huge.
That's certainly what the appeal court concluded. The jury, after just 3 days, found Picker guilty. All 3 counts. They believed Donna. And it seems highly likely those improper trial tactics played a part in destroying Picker's credibility in their eyes.
Judge Howie then handed down the sentence. What was it again?
22 months for the firearm count, starting Feb 2000. Then 7 years concurrent for the 2 sexual assault counts, starting June 2001. Affected a total sentence. 8.5 years, with a non-parole period of 6 years. So Picker was convicted, sentenced, and facing significant jail time.
But he appealed. With that new legal team, Strickland and Humphreys, against Ingram and O'Connor for the Crown.
That's right. The appeal went to the NSW Court of Criminal Appeal in 2002 before Justices Beazley, Bell, and Smart.
And the core arguments on appeal were focused on that unfair trial.
Exactly. Ground 1. The prosecutor's improper cross-examination, forcing the liar questions, implying recent invention caused a miscarriage of justice. It was prejudicial, unfairly shifted the burden of proof.
Ground 2. Picker's own trial lawyer failed him by not putting his version to Donna properly, the Brown v. Dunn issue, which then allowed the prosecutor to attack him unfairly, almost an ineffective assistance of counsel argument.
And ground 3. The trial lawyer's attempt to fix the damage with the notes in re-examination was totally inadequate. Plus, the inflammatory closing address added to the overall unfairness.
And the appeal court's decision, March 20th, 2002.
Unanimous. Decisive. Appeal allowed. Convictions quashed. New trial ordered.
Justice Smart's judgment really laid into the trial conduct, didn't it?
Absolutely scathing. On the improper cross-examination, he called it impermissible, unfair, creating illicit prejudice. He stressed how damaging this was, specifically in an oath-against-oath case, as it deflected attention from the critical issue, whether the Crown met its burden of proof.
What about the defense lawyer's failure to put the case?
He agreed that was a problem too. Said the failure to challenge Donna on details like, "Rain does it to me," directly led to the objectionable cross-examination and had a telling impact where credibility was everything. A clear miscarriage of justice.
And the attempt with the notes.
Deemed insufficient. The jury didn't get the proof, just Picker's word. And Justice Smart also noted the florid closing address, how it emphasized fabrication and lingered in the jury's mind despite the judge's summing up.
So the combination of everything meant he didn't get a fair go.
Precisely. The errors were too fundamental, went right to the heart of the credibility contest. The court couldn't just say, oh, well, the jury probably would have convicted him anyway. The trial process itself was flawed. So the convictions were wiped.
Meaning, Eric Picker, after that judgment, was legally innocent again, pending a retrial.
Correct. He wasn't serving that sentence anymore. He won the appeal.
So what happened then? Was there a retrial? Did he face court again?
That's where the public record gets a bit hazy. The main source, the appeal judgment itself, obviously doesn't cover what happens next. There's no easily accessible public information confirming if a second trial took place or what its outcome might have been.
What are the possibilities?
Well, the DPP, Director of Public Prosecutions, would have reviewed everything. They might have decided not to proceed with a retrial. Maybe Donna Lucas understandably didn't want to go through the trauma of testifying again. Maybe they felt the passage of time or the issues raised in the appeal weakened the case too much.
Or maybe it was resolved differently.
That's another possibility. Sometimes cases are resolved with a plea to a lesser charge, avoiding a full retrial. But again, we don't have confirmation from the available sources. What we know for sure is that the original convictions were overturned in 2002, and Picker wasn't serving that sentence. The legal saga for him, related to those specific charges in that trial, effectively ended there in terms of the conviction being wiped.
Okay. So the personal story ends with some uncertainty in the public eye, but the legal impact of Picker VR is crystal clear and lasting. How did it actually change legal practice in Australia?
Massively. It became the case you point to about improper cross-examination. That rule against forcing the accused to call the complainant a liar, Picker hammered that home. The court's strong language, unfair, illicitly prejudicial, made it absolutely clear. Prosecutors can't do that. Judges now know they must intervene. The focus has to stay on the Crown proving its case.
And the Brown v. Dunn principle.
Picker became a huge cautionary tale for defense lawyers. You ignore Brown v. Dunn at your peril. You have to put your client's substantial alternative version to the prosecution witnesses. If you don't, you open the door to attack. Now, Picker also set limits on how the Crown can attack. They can't just use it as an excuse for those unfair recent invention questions. The proper remedies involve the judge maybe recalling the witness or carefully directing the jury not to assume someone's lying just because a point wasn't put by counsel.
Sounds like it put more responsibility on judges, too.
Definitely. It was a reminder of the judge's duty to be an active referee. Step in early, stop improper questions, control inflammatory closing speeches, and give clear directions to the jury if these Brown v. Dunn issues pop up. Picker gets cited in judicial training materials for sure.
And its relevance for those difficult oath against oath cases, particularly sexual assault trials.
Hugely relevant. It constantly reinforces the basics. Burden of proof, reasonable doubt. Juries had to be actively convinced by the prosecution, not just pick who they think is more likely telling the truth. And crucially, it underlined that just because an accused person can't explain why someone might lie, that doesn't automatically make the accused guilty.
What about the prosecutors themselves? Did the DPP change things internally?
Reports suggest yes. Picker became a key training case. Prosecutors are taught to avoid that kind of overly aggressive personal attack and cross-examination and closing no more fantasy novel-type language. And if a Brown v. Dunn issue arises because of a defense slip-up, the ethical approach isn't to sandbag the accused, but to raise it properly with the judge. Stick to the evidence, argue the facts fairly.
So Picker VR really resonates through the system, even today.
It really does. Law students read it, lawyers cite it. It's all about that balance between vigorous prosecution and fundamental fairness. It powerfully illustrates that even when dealing with serious allegations, if the process used to get a conviction is flawed and unfair, especially in a case turning solely on credibility, that conviction cannot stand.
It's a stark reminder, isn't it, that behind the often dramatic details of a true crime case, the nuts and bolts of legal procedure, how questions are asked, how evidence is handled, are absolutely critical for justice.
That's the core lesson here. Hopefully you now have a much clearer picture of this really significant case, the people, the timeline, the courtroom drama, and its enduring legacy in Australian law.
And it leaves us mulling over that fundamental challenge, doesn't it? In these tough cases where it's one person's word against another's, how does our legal system ensure we hear and respect victims while simultaneously absolutely guaranteeing a fair trial for the accused based only on proof beyond reasonable doubt?
Yeah, that's the tightrope the justice system walks every day.
Thank you for joining us for this deep dive.